All right, welcome everybody. I would like to call to order this meeting of the Town of Harwich Board of Health, Tuesday, January 20th, here in the small hearing room at the Harwich Town Hall. As required by law, the town may audio or video record this meeting. Anybody intending to do so, to either audio or video record this open session is required to inform the chair. Is anybody here or online planning on recording this session? All right, thank you. If those of you who are here, I'm assuming we still have to sign in on the back table. A little different setup here, but if you haven't signed in, please do so at some point here this evening.
It's my understanding too that you can be heard from your seats if you do want to speak on a matter and don't want to come up and sit. You just introduce yourself, but if you want to come up and sit and talk with us, by all means.
All right, we'll start. Do we have any opening public comments? All right, we can I think move on then to the December minutes. Have members that were present in December had a chance to review the minutes from December 16th? And are there any concerns or changes that anybody feels need to be noted?
Nope.
I did not find any either. Was there a motion to accept the minutes? Is there a second?
Second.
All right, vote.
Aye.
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 Right. All right, moving on to new business. We have variance request for 36 Beriah Brooks Road. This is related to the usage of a single compartment tank for an accessory dwelling unit. Is anyone here for 36 Beriah Brooks Road?
This is like
Hello.
contractor.
How you doing?
Nope.
So this is similar to the one that you had in front of you last month. It's a 2-bedroom, and they're looking to make the basement. The only difference with this one is that the ADU unit is in the basement versus a separate structure, but similar in nature that it has capacity for holding retention as provided in that guidance document from the technical bulletin that I gave you last month.
Yep, so this was, reading here, no proposed increase in bedrooms. The finished room was determined to be a bedroom originally, so there's really no changes except for officially kind of making it more of an ABU instead of just a finished room in the basement. Has anything that you want to add? Any points you feel you need to make to the board? Or does the board have any questions? I mean, we're just converting an existing bedroom into a dwelling unit. So I don't feel there's really any complications here. I don't have any questions if the board does not. Are there any motions from the board?
I move to approve the variance at 36 Beriah Brooks Road with the following conditions. Property is restricted to a maximum of 3 bedrooms, no increase in habitable space or square footage without further review from the Board of Health. If a pump in the basement is required, it shall not be a
Macerator.
pump. This approval letter and conditions must be recorded at the Barnstable County Register of Deeds.
Second.
Their vote?
Aye.
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 Perfect.
First one's easy.
Thank you very much.
Thank you.
Thank you so much.
We'll get that paperwork drafted for you this week and it'll be mailed out for you to have.
Great, thank you
recorded.
so much. Have a good evening.
Thanks, you
As
too.
well. All right, we are moving on to the variance request for the existing variance conditions. 114 Clearwater Drive, increase in habitable space for proposed sunroom addition.
It says 3 up front, we might as well just stay here. Dan Croto from Moran Engineering, and I'm here with the contractors, Kevin and Lori Wu from Schoolhouse Construction. The owner is away, so he's not able to be here. So the existing 4-bedroom house had a septic inspection fairly recently, I think it was 2016 or 17. Seems recent. So they have an outside patio in back, they have an outside deck, and they want to put a sunroom where the deck is. And I think that, I don't think I gave you a floor plan of the existing and the proposed, and a exterior shot of the house, looking at it just before the meeting. I don't think I gave you the, all the exterior angles, but it's completely covered in glass. So they're looking to just have a place to get away from the mosquitoes when that season kicks in right on the pond. There is an existing condition from the septic system, because it couldn't get the full distance from the wetland. It's far enough from the pond itself, but there's a wetland, 12-foot or so wetland around the pond. The leach pit, I believe, was 98 feet or something, it's close. Leach pit is also on the down gradient side of the pond, so the water, your normal water flow would be from the pond, would be away from the pond towards Nantucket Sound. Let's say it's already 4-bedroom. Adding this other room, I guess would bring it to 9 rooms, but by DEP would put it at 4 bedrooms also. But I think the review of the room itself is completely open to the outside, and all the windows, so I think it would meet the board's requirements for not being a bedroom.
Carrie, do you have anything to add with
No.
this one?
No, it's not, the proposed project isn't encroaching on the septic in any way. The one variance that they have is minimal. I don't think that this is going to create any problems. It definitely doesn't meet the definition of a bedroom, so.
Yeah, with all glass being around. There any additional questions from the board? Do we have any motions from the board?
I'll make a motion to approve.
Well,
And I don't think the conditions would change any, so if you approved it with the
approve with
condition
the
that the
existing
previous.
variance
yeah.
conditions?
Yes, approve with the condition, with the previous conditions.
Right.
Okay, second?
Second, and do we have a vote?
Aye.
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 Very well said.
All right.
Thank you for the review.
We'll do a letter for this, but it won't need to be recorded because the conditions are already recorded.
Okay.
Okay.
All right.
All right, next agenda item is going to be a hearing request for Phase 2 sewer extension, 8 Chickadee Lane.
That's me. How you all doing today?
Good, how are you?
Good, thank you. Thank you for having me. Or allowing me the time. Okay. Wanted to apply for an extension for hardship, because there's no way I can do this right now. I tried to go to the aquifer, and I just financially can't have another loan. Okay, I'm in a teetering on whether we're gonna stay on the Cape or not. as a 60-some-odd-year-old who's getting ready to retire, I'm thinking seriously about what we're gonna do. So that's my first issue. I've got a couple issues that may or may not help with the decision. I bought my house because one of the reasons I bought it was it had a new septic in it when I bought it, okay, and that was in 2013. And in 2018, a letter came from the town that said if it was under 10 years old, I didn't need to connect, okay? Now, I don't know if that's changed. I don't know what the story is with that. I have a copy of the letter if you need it. So I was, kind of flabbergasted that I need to, and it's gotten very expensive. My house is an older home from 1940 that is set back on the way back of the property, about 4 feet from the property line. So everything I have is in the front, so to connect for me is around $16,000, and that's just not doable. I take care of old people, I do odd jobs, so my income is very limited. It's a one-bedroom house with me and a dog, so that's all that lives there. Pretty low impact. And when I sell it, maybe we could figure something out then, because my feeling is that if I did put it in and then I sold the house, they're gonna redo all that septic anyway, because I'm sure the house is not gonna be 4 feet from the property line like it is now. Okay, so that's another issue. Okay, that's pretty much it aside from the map itself. I got letters from the town stating that I should connect, but when I look at the map, my little house is not in a shaded area, it's white. I'm assuming that's just an error, I don't know.
Yeah, so those
Okay.
maps are,
That's what I was saying.
this is a preliminary map,
Oh,
so
okay.
once the engineering happens, these
Well, and everybody
shaded
on
areas
my
can kind of
my
shift.
street did connect, so I'm the
Yep.
only one that didn't, as far as I
Mhm.
know. Because as a
Yeah.
matter of fact, I took care of, one of my clients was at the end of the street, and when we were trying to sell her house, because she was in a nursing home,
Mhm.
we connected her.
Yep, so
Okay.
this is just for planning phases, but once they get into the actual design, those boundaries can change.
Okay.
So if you received a letter, it
Yeah,
is
no, I
because
received
you were,
letters, and that's
yeah.
why I just wanted to be sure, because it was like, that's my little block right there, and I was like, I don't know if that means anything or not.
Mhm. Yeah, no, we definitely would want to try to capture that if we could, because
Okay.
that's the last little residential piece over there.
Okay, so that's pretty much where I'm at, though. It's like I said, I just can't do it financially. If I was able to, I would, and I kind of feel like if I did, when I sell my house, the tear down is from 1940 and undetermined. It's 2 cottages stuck together. For me, it's perfect, but for the next person, it needs a lot of work, and they're gonna tear it down. And again, the septic and everything is in the front and was brand new when I bought it. If I tear it out and hook up to the sewer, they're just gonna tear it out again when they have to hook up a new house. Because I kind of feel like if I sold it, that's what they're gonna do. It's a great location for that, but loses the Cape charm. And I don't need an answer now, I just would like to, I'm trying to plan for my future too, and it's very,
Understandable,
On the
and
borderline.
especially if you're thinking about selling and moving, you got a lot of things on your
That's
plate and
just-
a lot
this
of
is just another
things
expense
that
I
you're
was like, I
juggling and
can't-
things to think about.
exactly. So I mean, I
Totally
appreciate
understand
your time
that.
and effort.
You mentioned the letter that you received that said it wasn't going to be, or within the 10-year requirement. Do you have a
Well, it didn't
copy
say,
of said
it
letter?
just said that, hold on a second.
I'd love to see exactly how it's worded.
Yeah. I got a lot of letters. The one thing I do is save everything. That one. This one. Maybe I misunderstood it, or
And then I guess a follow-up question: what kind of time frame would you be looking for? Like, I don't know where you're at with your
well, right now
planning and
Right.
potential selling.
I'd like to have
where
another
you-
5 more years on the Cape. I like what I do. I enjoy the people. Dr. Dino's at least one of my clients. She's a sweetheart. I don't want to leave the Cape yet, but we have some family turmoil too, and I could be moving south if I need to. And if I have too many big expenses up here, I just can't afford to stay.
So when we were talking about extensions, we did give, for traditional systems, a 10-year, and for IA systems, 15-year from COC date. The system we have, the permit was from 2012 is what we have, so it would just be outside that kind of 10-year range and what the board
So it'd be
gave
10
for
years
just
from
an
what we had
extension of-
already
of
agreed
aegis
upon,
system.
the letter that I believe what we're talking about, the letter you got saying 10 years, would have been 10 years from the date of installment in 2012,
So
correct?
those age of system extensions have to be applied for on a case-by-case basis.
Mhm.
They're not automatic. This is outside of this, but I think what is being sought here is not the extension based on the age of the system, but a general hardship.
I mean,
Mr. Scales did explore the Aqua Fund loan program, which is one of the requirements that the board wanted to have happen. I'm not sure about the assessing programs and the relief that's offered through assessing, if you applied through
Yeah,
any
no,
of
I don't think
those.
I did that one.
Okay.
You know, I didn't know the steps for that. But this one I tried to do, and again, it became another loan, and I was like, I can't, they're not
Mhm.
guaranteeing that I'm gonna get it, or have to pay for it, and I can't, I mean, I'm happy to pay for it, but I just can't have another bill right now.
I-
guess
current
wonder
septic
if
there at
this
the
would
house,
be-
when was the last time it was inspected?
I don't think it's been inspected since it was
Yeah, I don't
installed,
remember.
but I think that
I know it's been pumped, but.
the SAP program through the assessors might be a good avenue to explore, so if the board wanted to grant, like a year extension to explore that, and then take it from there to see, you know, what
Kind of where I was
circumstances.
leaning towards as it was, you said 5 years, and that would be a little much, but 1 year to explore some more avenues, I think is absolutely reasonable. You know, give you some more time to think about it. If those avenues don't open up doors for you, it gives you a little bit more time to think and plan on what the future may hold, and, so I mean, I
You can
think
always return in a year to have further discussions.
request
so it's
another
not-
extension if that's the case, you know, if there's other extenuating circumstances at the time, but, I mean, I feel at this point, a 1 year extension would be,
Can I just ask when the last time the system was pumped?
It was probably about 2 or 3 years ago. It's
Okay.
just ready to be pumped again. And actually, it's funny because when they pumped it, it hadn't been pumped in a while, and I wasn't familiar with the septic system because I'm from Connecticut, and going up there we had sewer, and so sewer's nice. I'm not saying it's not, you know, but there'd been a filter on it that said, "Oh, this is going to fail really soon, really bad." And I guess because when it was installed, it was a requirement to have this special filter put on, which afterwards they decided the filter made too much trouble, and that they said it was not a requirement now. So his question was, "Do you want the filter or not?" I said, "I don't know. If it's not a requirement, take it out," and everything's been fine.
Okay.
Yeah,
I'm
those
feeling-
filters require a lot of cleaning and
I'm feeling
maintenance.
new to the board. Have we had many of these requests?
This is the first
Yeah.
for this
Okay. Okay.
extension request.
Okay.
Yep.
And it's probably just me.
Well, I think there's other people
I
in the
just was
same.
wondering,
Yeah.
you know, because
Same boat.
it is difficult.
Mhm.
Well, like I said, I loved my little house. It's great, but I looked at the front of it, and I didn't think, you know, connecting the sewer was going to be $15,000 or $16,000. I'm like, yikes.
Very well.
Yeah. Well, it's a long distance. Like I said, the house is in the back of the property. Literally, the property bound is the Marini Estate, which is now Muddy Creek Preserve, and the property line is literally 4 feet from the corner of the house in the back, because it's a big pie triangle. So everything has to go down the front, and that's a lot. And again, I thought if they put in a new house, they're not going to put it back there because they won't get approval. Because I don't know what your setbacks are here, but I'm sure in Connecticut they wouldn't allow 4 feet from the property line.
yeah, it'd be tough.
Yes, it's been there since 1940, so, you know, cute little house. If you go by Chickadee Lane, I'm the one with the blue giraffes in the front. Well, that was from another client that I had. She passed away, but she had blue giraffes.
Any other questions, concerns from the board?
Well, I'd be happy with a year.
I
That
would
be
like to
great.
give a 1 year extension, if that's what we all agree upon. Is there a motion from anyone on the board?
Motion to, give 1 year extension,
Okay.
come before the board again and see how
See where we are
circumstances
then.
are.
Okay. Because again, my financial situation changes. My clients come and go, unfortunately. And unfortunately, when they need a lot of work and I'm making good money, that's usually for a short amount of time because they're needing more personal help and more help before things get really bad.
So the only conditions that I would ask the board to consider is 2 and 3 on that, for options for motions, just so it's out there that if the system becomes an environmental hazard, then obviously connection should happen.
Right.
And then no building permit can be issued, obviously if there's an event of, you know, something unforeseen that we don't want to happen, we would work with building permits, but if it's just to upgrade or, you know, we would ask that those, you know,
Right.
that the sewer come first.
No, I had been thinking about different things like an ADU unit, so I could
Mhm.
work on this house or get rid of it, but unfortunately, there's no money for that,
Yeah.
you know?
And then I would definitely explore the programs at the assessor's department, because they may offer some financial relief that you might be able to look at exploring and just giving you some relief in general, but.
Okay. We'll give it a shot. I'll
Yeah.
take what I can get and we'll just one step at a time.
All right. So to clarify, I would like to move to approve a 1-year sewer extension on the request for a Chickadee Lane with the following conditions: that should the existing system become a public or environmental hazard, it must be remedied immediately. And 2, that no building permit should be issued until the dwelling on the property are connected to a municipal sewer system. Do we have a second?
Second.
And a vote?
Aye.
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 Thank you very much. I greatly appreciate it.
Thank you.
Just be careful going home because it's icy. I walk the dog on my street. It's dark and you can't see the ice and it's, you know,
Yeah,
but it's a great, quiet street. Don't want to leave it.
great.
Thank you.
So that was pretty good. One more and you guys are out of here, right?
Almost, not quite though.
Not quite. A little follow-up. We'll see.
Yeah, we got a presentation pending too, so.
Okay. Well, thank you again. I greatly appreciate it.
Mhm.
And you'll send a letter then?
We will send a letter approving the extension.
Awesome. Thank
Yep.
you very much.
All right, next order of business is a violation appeal request for 71 Main Street Extension.
Good evening, folks. My name's Rick Hamlin. I'm the owner of 73 Main Street Extension. I also own the surrounding 25 to 30 acres of cranberry bogs, and I've been out there for probably about 30, 40 years. I'm a licensed CSL, HE, real estate broker until a couple of years ago, MCLP. I'm a hands-on landlord. My tenants will affirm that I am a good steward of my bog and my buildings. I'm here because I do and did the right thing. I pump my septic tanks every 2 to 4 years religiously for maintenance purposes. And as I age and prep for retirement, possible sale, I had 71 and 73 Main Street Extension septic systems inspected. They all passed. However, the septic inspector used a template on the inspection forms, and the report did not change the type of establishment, which is section D2 on 71 Main Street Extension or 73 Main Street Extension. He claimed auto body shop on all 3 buildings. 4 Evergreen Way was done at the same time. For lack of a better term, I'm here because of a clerical error. Director Shona was, did I pronounce that correct?
Yeah.
Was good enough after explanation to correctly change the violation from 73 Main Street Extension, but based on old websites provided by the current tenant, would not change 71 Main Street without a hearing. What I have here this evening here, and I have the originals for the director, and I have 2 notarized affidavits, one from Patriot Classics, who is the current tenant, and one from Chris Johnson, who is the manager of Northside Auto Body, confirming that auto body work is not performed at 71 Main Street Extension. The description of what is done is here, and I also have an August 18th letter from 2015 when I built 3 additional buildings on Queen Anne Road, 289, 91, and 93, at which point that was my first experience with tight tanks, and I appealed it with the state. This whole tight tank issue was based on CMR 248 10.09 or 248 CMR, however, whatever, excuse me. And it is a gross misinterpretation by the state in what is required for tight tank installation. And I'll get into that. I appealed at the state level. I had several letters that went to the state, and I could not find my file, but I also had the Harwich Board of Health against the tight tanks in 2009, who wrote a letter in support in opposition of tight tanks, the plumbing inspector in the town of Harwich, as well as the plumbing inspector in the town of Dennis. I had 36 signatures that represented business owners of 250 to 300 other businesses that were opposed to this. So the originals go to the director. There's a copy for the executive assistant, and if you'd pass, I have these for the members. Once again, Patriot Classics is basically a welding and fabricator. They did at one time do service work. That model has long since changed. Northside Auto Body rents his spray booth to Patriot Auto to perform body prep and painting at 360 Holcomb Road in Dennis, Mass. They perform no oil changes or service work. Brief discussion of 248 CMR 10.09 interceptor separators. I discussed the letter. It describes floor drains, commercial motor vehicle parking and storage facilities, but it specifically refers to the MWRA, which is the Massachusetts Water Resource Authority and the sewer district. The intent of that CMR was basically for the thousands of automobiles that go into parking garages in cities like Boston. And in slurry weather like we've had the past few weeks, you've got salts, you've got spray, and when those vehicles would go into the parking garages in the major cities, the drippings would fall on the floor, and they would ultimately go into the MWRA, into the rivers system. That's what the intent was for this, and it was specifically directed towards those connected to sewage. The buildings that we build here, and I've built dozens of these buildings here on Cape Cod. I own close to a dozen. As I said, I'm a hands-on manager. That doesn't come easily. But these buildings are not connected to municipal sewers, although that may come. And when that day comes, we'll deal with that then, much like the gentleman who was here a moment ago. CMR 248 is a complete stretch. I want to explain something about it. In my letter of 8/15, it was 8/18, I'm sorry. I made note, paragraph on the second page, and I circled it in yellow. The requirement to install so-called separators is an excessive interpretation of the regulation. In its simplest form, a motor vehicle of any type can park outside on the pavement, concrete, impervious, or pervious surface of any type and allow anything to drain onto the surface and eventually into any type of drainage system. Now remember, the operative word is outside. However, under this interpretation, a motor vehicle may not park inside of a commercial building without the drippings, for lack of a better term, collecting on an impervious concrete floor to be swept up and disposed of later on. The interpretation of the regulation is excessive and costly, resulting in an additional $15,000 to $30,000, and that was 10.5 years ago. It's now a minimum of $25,000 to install a floor drain that basically serves no purpose. As I said, I submitted 36 signatures. Now, I would like to say that everyone in this room who parks a vehicle in a garage under this interpretation is in violation and is a detriment to the public. But if you park your car and your vehicle in your garage, in your driveway, whether impervious or pervious, you're not in violation. there's no sense to this interpretation whatsoever. Summary. The requirement to install a tight tank on a grandfathered 40-year-old building, which use is not auto body. You have the notarized letter in front of you from the tenant. The cost is excessive, $25,000 to $30,000 for what amounts to no benefit to the public. At the time, the Board of Health of Harwich, the Harwich Plumbing Inspector, Dennis Plumbing Inspector, and 36 business owners are all, no one's in favor. And as late as last week, your Harwich Plumbing Inspector inspected a property of mine, and we had this discussion knowing that this is coming up, and he is still not in favor of this. But his hands are tied, because the state basically says, if you don't enforce this regulation, we won't renew your license. That's, I believe, called extortion, but that's the threat that all of the public plumbing inspectors are under, and they're still under that same threat. Now, if imposed, I'm left with three alternatives. One, I could possibly not renew the current tenant's lease who's operated for 10 to 15 years without incident. Now, just for the record, I recently did not renew a lease of a tenant that was in a property for 10 to 15 years because he created a significant health and safety issue that took me 2 years to resolve. First verbal warnings, written warnings, etc. When the lease came up, I didn't renew it. That tenant is gone. I'm a hands-on landlord. Secondly, I could continue in violation indefinitely, but as a member of similar boards in other towns, that's not my intent at all. Third, I can install a tight tank that will cost between $25,000 and $30,000. It will add no benefit to the public health whatsoever. If not, in fact, expose the public to detrimental conditions. It's a gross interpretation, and I want you to just briefly understand the way a tight tank works. I've built 50 of these buildings. The general surface, especially in a grandfathered building, is flat. If someone spills oil, they're going to put Speedy Dry on it, and they're going to sweep it up. They're going to absorb it and sweep it up. They're going to do the same thing if it should happen outside. If it goes into a tight tank, it doesn't serve any purpose. It just gets contained into a tank. And you know how long that could sit inside that tank? Indefinitely, because if it doesn't reach the 300-gallon minimum, it just sits there. That all being said, I respectfully request and thank you first for your time in my long dissertation. I am well-versed and experienced in this issue, well-versed and experienced in managing these properties, and I simply request that based on the use not being that of auto body, that the violation be terminated and that we simply be allowed to operate and continue. Or continue to operate.
So, I'm under the understanding this initially was a violation of 71 and 73. That was a clerical error, and you made a correction for that, correct?
Correct.
Okay. You mentioned earlier 71 not being auto body is being used for storage. What's being stored there?
I have a contractor who operates a contracting business. So in and out vehicles. Another fellow has dry storage in it, and then we have Patriot Classics.
So, the information that was available to us when we did our research, and I have some of the screenshots from the website description of work, is what prompted us to actually do the violation letter, that and a letter from 1988 from Mr. Hamlin saying that if there was any auto body work that he would install the floor drain. We do have the floor drain regulations that were enacted after that building was installed or built. It's also my understanding that under today's plumbing code, any bay with an overhead garage is required to have one of these, but I don't wanna speak as an expert on the plumbing code because I'm not, so that's just my understanding, but I could be wrong in that. If the board felt that the affidavits from the business owners stating what they do is sufficient enough to revert the violation, then we could move in that direction. If the board feels that the violation should be upheld.
I would like a little bit more time to like really read these affidavits, if you don't mind waiting a month.
Because I was just interested when you said a spill, what was a spill? You put a little pad? I
A
don't,
theoretical spill of any type on an impervious surface, so a garage floor.
right, so what was the remedy that you were saying?
The remedy is, there's a product called Speedy Dry. It's much like cat litter.
I was
Okay.
just gonna
Just
say.
sprinkle it on. It
Okay.
absorbs whatever that spill may be,
Okay,
okay? Whether
Okay.
it be oil, gasoline, whatever the case may be.
okay. I was
Even
just wondering.
soda, tonic, I guess would be the term.
Okay,
And that's the best way to
okay.
treat these products. Mr. Chair, I'm here specifically, not delayed my trip to Florida. I'm in Florida until late March. So pending,
You could join us online.
I have a hard enough time joining my own board online, and just don't use Zoom. But, I would ask that the letters really take about a minute or so to read, and they are pretty clear. I would request that, maybe we take a minute. I know that Mr. Eldridge is waiting behind me, and I wouldn't want to hold him up too much, but seeing as there's not too much else going on, I'm sure.
We do have somebody else waiting to give the board a presentation as well, which is why I'm trying to keep, the meeting on time for everything else as well.
Is anybody else in Florida familiar with Zoom that you're with?
Sir, it's a personal issue. It's just, I won't do it.
Well then, I would like time. I mean, I'm willing to look at all this and come to an agreement, but for you to just sit here and say, no, I'm not gonna make a Zoom meeting next month, when that's all I'm asking for is a little bit more time to look at the new information you brought to me today, I'd have just to agree to move on and consider it still to be a violation.
I
I'm willing to look at it,
I
if you
would-
can meet us next month on a Zoom meeting. You don't have to be here physically.
I'll be back in March. If you have a meeting in March, I'd be happy to
Every month.
postpone till March.
Is
Okay.
there somebody that could come and represent you, or?
It's my building, my problem. I accept the circumstances, and sir, the clerical error was made by the septic inspector, not anybody else. He took a template and just overwrote the template and basically rewrote everything from previous inspection. And he really messed up on that. And that is, it's why we're here.
Well, we're here
So-
because we also did the research, and the research in the business states that it did do automotive services.
I do understand that, and I have had conversations with the tenant, and, that was a past use, maybe in violation then, but not now. He has changed his entire model. So with that, if you would like to extend to the March meeting, which if it's like the third week in March, that
I will,
I can do.
absolutely.
It's the second weekend, it's March
So you can
17th.
also call in on your phone, landline as well.
That
If that's an
I have to do on my own board, so I don't mind that at all.
Yeah, you can call in, you don't have to,
But I would
Zoom
still
in.
prefer to,
Be in person.
Your preference would be here in person, and
Yes, sir.
postponing it to March is acceptable to you? I would like to do that.
If the board would make that motion, I'd appreciate it.
Okay.
Make a motion to extend the conversation to March.
Any second on the motion? A vote?
Aye.
Aye.
And that meeting, quote, definite is the 17th of
17th,
March.
yeah.
Thank you very much.
Thank
you.
you.
Thank you.
By the way, I know I can't give Matt a reference, but I've known him for over 40 years, and I highly recommend.
Thank you, Rick.
Great guy, he would be an asset.
Hello, I am Matt Eldridge, the applicant.
All right, moving on to last of our new, which is E, approval of new utility installer license without require 3 letters of reference. Matthew, go ahead.
Basically, I probably started doing septic work with another guy back in about 92, 93. At the time, he had an excavator, I had a Bobcat. We kind of found it worked well to work together. He was kind of my mentor, taught me, how to do things. He and I did that together for a number of years. My primary function was to put things back together that he tore up. I called it fixing Ernie's messes. So we eventually, as subcontractors, went to work for Robert Hour, and we were their residential installers for a number of years. Ernie has since retired and left the Cape. I got my septic license thinking it covered the sewer 5-6 years ago. Septic work, I bought a smaller excavator. I'm limited with septics because you need a bigger excavator to set the tank. Smaller excavator, I can do the sewer work. So I know how to read plans, I can follow directions. I think I can do this, I know that. There is a system of checks and balances in place. I do a job, I call for an inspection. If I fail the inspection, I don't get paid for the job. If it turns out I am truly inept at doing this, then the town has the option of suspending the license, not renewing the license.
So, previous, it was when the utility installer license was new to the town of Harwich, that was the requirement for the 3 letters of references. There is a lot more need for the utility installer work, so we will probably see more folks, and I think, if we do have any issues with Mr. Eldridge, which we don't know that we will, but if we have complaints, we could
issues, I'll give you the license back.
we could easily,
Oh,
have a discussion,
I've been a
suspend the
contractor in town for
license.
37 years. Haven't had any troubles.
I mean, we do have the email here from Judith Giorgio in the town of Chatham endorsing you.
I only
I mean,
hold licenses in Harwich and Chatham. I didn't want to extend myself. Dennis, Yarmouth, Hyannis. I like working close to home.
It might not be as formal, but I think we can certainly include that as at least 1 letter.
Yeah, that's the letter
And
of
it's-
reference, it just doesn't have 3.
Okay.
Well, there was another one from the Chatham Highway
Yes,
Department.
Yes,
Municipal work's usually done by the bigger contractors. It's harder for the smaller guys to get those references and experience.
and we need more installers, so I would be inclined to approve the license without the references, and knowing that if we run into any issues down the road, we can always,
I think having a strong reference from the town of Chatham health agent, definitely, with that as part of the couple letters we have received, I would agree with Carrie, and
Thank you.
I would say we move to approve. Does the board have any other questions or concerns regarding this issue?
I don't think so.
Do I have a motion from the board?
Motion to approve.
Is there a second to
Second.
that motion? All right, and a vote?
Aye.
Aye.
Thank you. Thank you for your
So
time.
when you do apply
Thank
for
you
your
for your
license,
patience.
we'll just approve the Board of Health stuff because they approved it this evening.
Okay, thank you.
thank you. So I don't know if you want to jump to our presentation with Mr. Hope online, and then we can come back to the remaining,
Why don't we do that?
so we don't hold up Mr. Hope any longer than.
You've got to unmute your microphone, Alan. Bottom left of your screen.
I think he just turned himself
Well,
off.
if you can turn off his camera, you can turn on his mic. we just gotta walk him through it. Alan, same buttons, but right now your camera and mic are off.
If it's easier to just leave and then rejoin the meeting, you can do that too.
Well, while he is figuring out how to unmute, if you want to go back to permits,
Yes.
Yeah. Why
Only
don't we
a
do
couple,
that?
Lindsay.
we have new ones, and then we have the renewals as well.
All right. New licenses listed below. Are there any questions regarding the one new license that we have here listed?
Is that the Harwich Fire?
Yep, that's the new property on Bank Street.
So what does that entail? I'm just curious.
So that's going to be mostly functions, so if they host like dinners,
okay.
or I think there's going to be a catering business out of there as well,
Okay.
RDA
The old
catering.
fire station, is that what you're talking about?
Yep.
Okay.
Is it upstairs?
Function hall is downstairs, and then
Downstairs.
apartments are upstairs.
Okay, very good. Okay, that sounds good.
I'm gonna get over there and walk through those new conservation lands one of these days.
Not tonight.
No, not at all.
You'll look full of brick.
Not even in my Snuggie.
Exactly.
And then, looking at the renewals of previous licenses, any questions or concerns there, or any additional questions or concerns from Carrie?
Oh, we got
There you are,
Alan
Alan.
off
Get the
mute.
mic going. We can hear you now.
I have help.
Okay.
Yeah, ready?
Before he gets his camera up.
Oh, thank you. I'm sorry, I'm not too technically up to things.
All right.
Need help.
Alan, give us just one moment, please, then, and we'll be right with you.
Thank you.
Any motion on the permits?
Motion to accept.
Second?
Vote?
Aye.
Aye. Permits accepted. All right, Alan, you're up.
Thank you, thank you. Stephanie, thanks for connecting with me. Mr. Chairman, there's a wide topic here, and I'm sure you've got a lot to discuss after my presentation. So, can I ask a question? Where do you want to start?
Well, I did do a little bit of reading on this, with your what you've given us, and I guess, because this is my first experience ever with receivership, totally new to me. Reading this right here, so I guess basically what would be the benefits, not only to the board, but to the broader community. Why would receivership be better, than continued enforcement? And what responsibilities would shift to a receiver, and what authorities would be maintained, by the Board of Health. But I understand this is a presentation from you. I would ask that it, be kept as a factual presentation and not a sales pitch. But we're all ears, Alan.
Thank you, David. So, a bit of history, and I'm not a sales pitch. The receivership program started in 2008, and it started because of public properties. If you recall, we had a foreclosure crisis then. and the Attorney General introduced a program for receiverships in which the objective was to bring as many properties into compliance as possible. So that is what we see today is an evolution of the traditional, what I would call, identify and fix issues. At that time when it started, it was properties that were boarded up, maybe needed reboarding and repair. And today, the receivership program, as many programs as you're faced with, have evolved into more sophisticated forms of demand placed on the boards, health departments, building departments, treasury, and where we are today is dealing with issues like hoarding and ADUs and other more mental health issues, for example. So the receivership has evolved from just a fix and repair type of responsibility to more dealing with issues like providing postal services, to hoarding to hoarding cases, to cases in which you have properties in which the occupants, sometimes there are occupants who are underage and they're de-letting issues, and so forth and so on. So that's a bit of the history. The responsibilities of the boards has been very consistent, in which the boards will maintain the ultimate authority in deciding what is in compliance, what's not, and monitoring the compliance process through the courts and through the receiver, and then giving the final sign-off at the end of compliance. So I'm happy to say that boards have retained most of, if not all, of the responsibilities when it comes to ensuring that properties in your town, in your municipality, are in compliance. That's a quick summary. I'll be happy to entertain. Sorry, excuse me. Let me just mention one other thing as this whole system is evolving. What I'm finding today, and this is now involving or including the Treasury Department, many of the non-compliant properties are owned by property owners who are maybe unwilling or unable to bring their properties into compliance. As a result, real estate taxes have not been paid. And as a consequence of that, of course, is the town is not being able to recoup the revenue that's due to them. In addition to that, building and housing departments have the authority to issue fines and penalties. And many times those fines and penalties are being recorded as liens against the property. But because of the lack of responsibilities, or I should say, on behalf of the municipalities, they lack the ability to enforce the rules and regulations that they are responsible for maintaining. And as a result, this receivership program now offers a bridge for the towns to be able to depend upon another resource, which the towns don't have the resources or even many times the experience or knowledge to enforce. I don't know, Mr. Chairman, if I've covered all your questions, but I'll be happy to respond to any questions you may have.
You did. I'm listening. You're developing more questions as we go here, Alan. So you mentioned receivership and the enforcement of policies. How does a receivership step in and enforce policies that, albeit maybe, the board and the health department are having difficulty enforcing at times, how does a receivership come in and do that more effectively?
Very good, okay. So, it happens, the receiver is, think of an appropriate word, the boards of health department, and maybe the building department as well, are the triggers to identify and report on a violation. Once that is done, that violation is handed over to a person called a receiver. The receiver then assists the municipalities in redefining the issues in preparation for a court hearing. And then the receiver would appear in court on behalf of the municipality to represent the municipality's complaints. Now, let me just mention on the side what is important. I think it's important to facilitate this whole process for the municipality to have their own solicitor. The reason being is the solicitor would be representing the municipality's interests, while the receiver, as I mentioned, is the bridge between the municipality and the courts. The receiver is an agent of the court and is supposedly an independent body who reports to the court as well as to the municipalities. So you are the trigger for bringing the violations to the receiver's attention, and the receiver carries it from there to the court to get the, not only in this case, the compliance to be adjudicated, if you will, or responded to, but also to ensure that the municipality is reimbursed for any penalties, taxes, and so forth that is due to the municipality.
All right. Another thing I just wanted a little maybe further explanation on or clarification. You had mentioned, when I asked, what a receivership really does or what's the benefit, and you had brought up how initially they were really started, during the housing crisis and was more identify and fix issues was the exact phrase you had termed. But then you went on to say some of the things that now these receiverships work with. You had mentioned ADUs, but a few other things that you mentioned at that point really perked my interest. You had mentioned hoarding, mental health issues, and social services. How does, in the case of issues where maybe there's been a report and a violation, and when a receiver is involved and there is coming from the perspective of a nurse, as I am, when somebody that you start working with in the public, in one of these situations who's under violation, and who makes the determination that that person needs, assistance and mental health assistance and social services, and how do they receive it?
Good question. So let me give you maybe one example, and I won't address the mental issue. That's something relatively new and it's complicated. I'll give you an example of where we use social services that I provide. So in Foxborough, in fact, there's a 11-unit building, seven units residential, 4 commercial. In one of the seven residential units, there was a case in which the apartment needed to be de-lettered. There was a single mother with 3 children living under the age of 6 that needed to be relocated, which we were responsible for, to a hotel. And I think they stayed there for 3 weeks while the de-letting process was done. They then moved back to their apartment. Another case was a hoarding case in Rockland, in which there was a 65-year-old lady, a bit of a sad story. I need to tell you a bit of the story, just because you realize the complexity of the situation. 65 years old, started hoarding. She wasn't hoarding. She had rented out 2 apartments in the basement to 2 young men who went around the neighborhood collecting lawnmowers and barbecue sets, brought it back to her house, stored it in her house, and was selling it. Now, that became a hoarding issue that wasn't initiated by the property owner. But it was a violation, and we were called in by the health department to bring this property to compliance. And part of our responsibility was not only relocating and making sure that this elderly lady was accommodated, but we also needed the support and paid for the support of the police department who accompanied us to enter the building because she did not want to get us into the building. So that involved the police department. Then of course, because there were hoarding issues, there were gasoline tanks and what else, so that involved the fire department. It was the responsibility of the receiver, not the town, to coordinate all these activities to bring the property into compliance.
I have a couple questions. Is there a fee for these services?
Good. The fee is not paid by the town. The fee is reimbursed by the property owner who's in violation, and the court determines what that fee is. The only responsibility of the municipality or town is to ensure that they hire an attorney who represents the town's interest.
Are there any other towns on the Cape that have this service with you?
I've made presentations to a number of towns on hoarding. It was in Dennisport some time ago. So no, to step back a bit, this whole, well, I would say the whole concept, the revolution or evolution in receiverships has not been well communicated. It's no longer the fix and repair issue. As I said, it's become far more complicated, and as a result is, I think most towns, not only on the Cape, but particularly in Western Massachusetts, are beginning to only understand now what the services are available to them. Just standing back, I think you asked a question, Mr. Chairman, about what does it do for the roles and responsibilities of the Health Department and the Board of Health. What the receiver would do is, in many cases, add to the productivity of the municipalities' departments, whether it's police, health, building, because there's a duplication of efforts that takes place in many municipalities, simply because municipalities are trying to understand. Your question is what receivers do, and receivers takes over many of the responsibilities of the departments, not only integrating the information, and the information might be between the Treasury Department, Health Department, Building Department, and so forth. They're preventing or discouraging the duplications of effort that your departments would have to replicate simply to enforce a violation. And I've noticed that many times health officials make repeat trips to try and communicate with the unwilling or unable property owners to bring their properties into compliance. And unfortunately, there are CMRs to follow, but many times it's the discretion of the individual official to decide how often, when to go, when not to go, and many times, particularly when you're involved with tenants or occupants, the health departments, building departments, don't have the authority to really enforce the regulations which you follow in most most instances, but it goes beyond the boundary of your responsibility. And I think that's what creates a lot of confusion. And that's why I think what I would call outsourcing many of your responsibilities to an independent body who's responsible to the court, is an agent of the court, but at the same time reporting back to you is very important.
How often do the occupants of these properties stay in the property? And how often are the properties sold after, so the receiver can get reimbursed for repairs that have been made and expenditures?
Well, I think it's a complex question that you just asked, so I'll try and answer it. First of all, the property, the occupants have to follow the rules and regulations dictated by the court to the receiver. So there's standard procedures. You know, I would give notification to the occupants that on the February 1 here we're going to with an inspection with the health department, with the building commission. So we give notification and we do the inspection. We then re-notify in writing many instances the occupants that these are the results and these are the actions that are going to be taken. But what complicates the matter is it's not the occupant that's usually responsible to bring the property up to compliance. It's the property owner. And many times the property owner is absent. In many times, what I've noticed is banks, particularly banks who are not local banks, hire third-party service providers. And it's not the responsibility of the municipalities to identify who those parties of interest are and then provide particular notifications to them. This, to me, is going beyond the responsibilities of the health building department. So that's when the receiver steps in. And so to answer your first question, I think, Mr. Chairman, what happens as soon as the violation is identified and your departments have taken appropriate action, 3 notifications and documented and so forth, and there's been no response, that's when you should feel free to report this witness to the receiver. So I don't know if I answered your question, but it's a complex question. Each case is different. You know, it's different for, as I explained earlier, for hoarding cases. Hoarding cases, you know, might be, unfortunately, there might be an elderly person who's not cared for by their family, or it's difficult to know who the heirs are of a property. And that's not your responsibility to spend time identifying who they are, giving the proper notification. And I mentioned a case in Foxborough. It was an absentee landlord, and that person didn't follow any notices by the board regarding violations. And I had to call the state in this case. It became a state issue because it was a lead issue. So it became more complicated than what I say, the traditional knock on the door. This is who I am, and this is what needs to take place. So it depends on each case is different.
There's 2 of us on the board who are case managers at Cape Cod Hospital, and as I'm sure you know, Cape Cod is full of elderlies with little income. A lot of them don't even have medical insurance. And if they're hospitalized, our social workers take care of these situations you're talking about. But if a person has no money, no insurance, owns the home, what do you do then?
Once again, what's going to direct me what I can do in the courts. So in this instance, I might get a notification from the organization that this person is elderly, doesn't have insurance, needs assistance. It'll be usually what the court does is it gives the receiver the right and permission to relocate that occupant as I mentioned in the D. Lady case, we repositioned the single lady with 3 children in a hotel. We'll do the same in your case under the strict orders, directions of the court for a period of time that it took or takes to bring the property into compliance.
But
Then
what do you, how do you pay for that if patient can't pay?
Okay, so what happens is the receiver is directed by the courts how much their fees could be. I'll give you an example. The receiver, based on your example that you quoted, would prepare a budget. And in the budget would include expenses like the relocation, the repair, and so forth and so on, which has to be approved by the court and monitored by the court. And that the way there's
But who pays for this?
Oh, the receiver is paying for this.
No, who pays for all these services?
Oh, the receiver does. Okay, I think your question is, the receiver has to bear all these costs because they're preparing the budget. Now, what happens after the expenses are incurred, the court will determine, as I said, the amount that needs to be reimbursed to the receiver. How that is done, how that receiver will be reimbursed is once again determined by the court.
So they may set up like a fee payment for the property owner to pay you back over time, or they may
Yes,
force the property to be sold?
well, once again, the court's going to make a decision on an individual basis. I mean, if it's an elderly lady person that doesn't have any support, the goal of the court, of course, is to justify what the remedy is to the violation. And you identify what the violation is, which is going to determine what needs to be done to the property, and I guess the court will determine the occupant what needs to take place to ensure that occupant is safe and maintains its their well-being. So I'm a bridge. I'm a receiver. I'm appointed. I'm approved by the courts. Let me be more very precise here. As a receiver, because of my credentials, I'm approved by the courts to be a receiver. So I have qualifications.
Okay, I have another instance. If a patient does not have capacity, does not have any relatives, cannot make any kind of medical or financial decisions, what do you do?
Oh, well, once again, the court is going to direct me to do, and I'll be working with the nurse. My social worker will be working with the nurse or the person that will identify the violations and make recommendations to the court. You're entitled to go to court anytime you want and make a representation. The purpose of the receiver is to carry that information to the judge, and the judge will use their discretion. Now, I know in one of the instances I had, I think it was in Lowell, if my memory goes me right. What happens is there was a situation like that, and the housing authority then adopted the individual that wasn't capable of, for some reason, of going back. They needed assisted living. They needed some other support systems on an ongoing basis. Okay, the receivership is to fix the violation, and the court gives direction as to specific direction how the occupant, as I mentioned, whether it was a single mother with 3 children who was 6 years old, or whether it's an elderly person, as to the direction that take place.
So each case is kind of handled differently, and based on circumstances and information provided, the courts then set a plan for how this receivership is going to be handled.
Yeah, it has to be, because each situation is unique, you know. I mean, the individual that you mentioned might have relatives or may not have relatives. There might be long-term care, but it's a short-term care. I'm not in a position to make that decision. So that's what the courts are for. And once again, I'm the bridge. I'm the person that takes the information that you provided, with you maintaining your responsibility and authority providing an interpretation that the court understands without having you to spend additional resources to go through all the rules and regulations that a person has to get the court's attention. Many times the courts will not even hear a case because it's not well prepared. And that traditionally happens in times when there's been penalties or any interest that are due for real estate taxes that have not been paid. There's a statute 40U which the towns need to follow in order for this to be considered by the courts. And of course, the health director or building commissioner who's ever initiating this issue needs to follow the CMR's 105 CMR's 410 for it to be valid, to have good standing, to be presented in a good way to the court. That's why I recommend that the town solicitor gets involved with this and works. I'm not an attorney, by the way. It works with my attorney who's familiar with the processes, and they, from a legal perspective, support your application to get compliance on these things.
Well, Alan, I think part of the, if I can step in, I think the concern here, with the example that was brought up, we have a lot of elderly here on the Cape, and what about a situation where an elderly person owns the home but really doesn't have the funding? And a question was asked about who is responsible for paying for all of this. And before you answer again, you just kept saying, oh, it's the court, it's the court. The court decides who's it. Yes or no? Is the little elderly lady who can't afford your services, I don't care how many or what the court does, ultimately it's them that is going to be on the hook for the bill. You can't charge them more than the court decides, but the bill is still their responsibility in that case. And I think some of the concern is that when we give that up to a receivership, that we then, where it's totally determined by the court, I think some of the concern is that we lose our ability to act with compassion and a little humanity in instances where that might be necessary.
Yeah. Now, Mr. Chairman, you're right. That happens. I've seen it happen. And once again, I wish I had the authority or even the funds to go and say, this is this case needs to be, something needs to happen to.
Can I ask a question? Where does elder protective? What about elder protective services? How do they play a role into what you're saying?
Oh, well, I have my own social services too.
Well, we have, the state has elder protective services in place.
Yeah. So, I'm sorry, so the question is?
I want to know what you feel your role is with our elder protective services that is through the state.
Oh, well, once again, I would work with you and the courts to determine what the outcome is for this individual. I mean, I guess you're asking the question, I'm guessing, what happens if the person doesn't have any funds and they can't be accommodated by any social services? Is that the question you're asking?
I'm saying that a lot of our people are already protected by elder services. So I just was wondering what the conflict would be.
I'm sorry, repeat the question.
I'm saying a lot of our elderly are protected by elder services already.
Yes, yes.
So I'm wondering what your role will be with elder services to protect the elderly.
Okay, good. So if they are protected, then my function would be to assist in the fixing the compliance and where they, let's take an example. It's an elderly person that was living in a unit, 900 square feet, that didn't have any screens on the window, and the property owner wasn't, they were renting, I'm assuming they were renting, and the property owner didn't take care of the property. In that instance, it would be, the violation would be for the replacement of screens, as a simple example. The property owner would be responsible for bringing that property into compliance. And while that is necessary, meaning to bring it into compliance, my responsibility, not at the town's expense or not at the occupant's expense, to relocate the occupant until the property is brought into compliance. My claim, if you will, for me.
Actually, Alan, while we're on that topic, and I was going to bring it up after you were done, but since you just mentioned it, I'm going to bring it up now. Earlier, and you quickly corrected yourself, but you used the phrase, it gives you the right to relocate somebody.
No, it doesn't. I use it, sorry, Mr. Chairman, it's too strong a word. I can't, look, there's going to be a person that's living in squalor. You can identify the issue as a condemnation. I know whatever the way you determine to identify what the violation is. Once the violation is identified, I would go to the court with that information, present it to the court, and the court would make the decision what the right way of dealing with that issue is. And the judge will say, his opinion, and it's a court order, which you see copies of, that that person can be relocated for 2 months. These are conditions that they would live in. In the meantime, the receiver would go and bring the property into compliance, and the property owner has to cooperate and do whatever necessary. I'm sorry, I don't have any rights. I have an obligation.
And in that situation, then ultimately the property owner is the one responsible for footing the bill for that 2 months of relocation, correct?
Absolutely. Yeah, because that's who's actually responsible. I mean, if a person is a tenant or even an owner that lives in a property that is not being into compliance, it's the property owner that's responsible. It's not the town. It's not the receiver. The court will adjudicate, decide who has to do what and when, under what conditions.
So receivership is essentially a tool in our toolbox that we can use if we are not gaining compliance with a problem property.
Tool that we can choose to
Yes.
use or not use.
Yes, exactly. So
Yeah.
I don't think it would be appropriate for every violation letter we issue, but there may be some extreme circumstances where we are getting nowhere, we're gaining no traction, we're not getting anything from the property owner,
I
occupant
could
or
see it
not.
being more used in instances where it's maybe not, we have a property owner that owns the property, but the occupant is one living there and penalties are brought and the owners are the one dodging. I can see it maybe being an effective tool in incidences such as that. I can see its benefits, and I would also share, I believe, what would be some of the concerns, like I mentioned before, about, I certainly, let me ask, I guess as a follow-up to that, when I mentioned like our ability or our, we don't want to be able to lose that ability to act with humanity and compassion. Should something get brought to a receiver, and I mean at that point, is it totally out of the board's hands until it gets addressed by the court and the receiver, or are we still involved in that?
Never out of the board's hand, no. It's never out of the board's hands. Never. The board is notified, companies can accompany the receiver in court. It's all transparent. That's the purpose of the court system. It's a check and balance. There's transparency there. You don't have the authority, I guess, so I'm using strong words again. I don't know if you want to, physically relocate somebody. There's a whole lot of liability issues. You don't want to do that. So that's why this intermediary called the receiver, who's an agent of the court, but reports back to and entitles the boards of health, health departments, building commission, anybody in the town to raise a hand and saying, I'd like this other point to be considered. Anywhere along the process that you or municipality is involved. It's for you to decide how much you want to be involved in this whole process. It's my responsibility, to report on a monthly basis, financially, operationally, responsibility-wise, to the court and to you. So I think in that way that you are updated as much as you want to be. You decide to become involved as much as you want to be.
All right. Any other questions from board members here?
Yes. What's the timing issue? I mean, you just don't go to the court, the next day you're in court. How does this whole thing work? In other words, somebody complains, or what?
Yes. Okay, so the complaint can come from any person, doesn't even have to come from the town. But usually it comes from the health department, boards of health, because they follow the CMRs, and you follow those regulations. So as you go to court, you have documented, according to statutes, followed certain policies and procedures which are accepted by the court. So I think an individual who's reporting that their neighbor is, I don't know, it's not, there are some non-compliance issues in the neighbor's apartment, I don't think they're familiar with procedures that can have this accepted by the courts.
But how long does it take to get a court date?
That's the question.
Ah, that's a good question.
That's the question.
I wish I knew the answer to that. As in this case in Rockland, for example, it became, when a property is condemned, for example, it's immediate. There's a special petition made to court, and if it's a life-threatening issue, it's petitioned. There's a special hearing, an emergency, and it's usually done, when I say immediately, the court decides on its own calendar, but it happens within days, I would say. Now, regarding the final compliance issue by the court, which you have to sign off on, by the way, that can take, depending on the case. So this hoarding case that I mentioned in Rockland took over a year. We went from housing court to superior court, and there are a number of reasons for that happening. So, the reason being there was a bank involved who constantly objected, but the court saw that within that year's time frame that the occupant was taken care of. And that's the main concern of the courts, is to be able to ensure the safety, integrity, well-being.
Oh. Caller, you're off mute. Thank you, Stephanie. Okay. Yeah, so these cases can take a while. Like Mr. Hope said, it really depends on the severity of the violations.
Yes, but once again, the court would hear you.
Yes.
If it became, depending on the urgency of the court.
And the judge is the one that's making all the decisions and setting
Yes.
time frames and doing
Yes.
that. And then the receivership comes in and carries out the actions that the court dictates.
Correct. And to repeat, once the judges relieve the receivership of their responsibilities, the judge will only do that once you have signed off that all the compliance has been met.
again, tool in the toolbox.
That's-
It's not,
Tool in the
not something
toolbox.
that you would use for everything, but it
That's
is,
the takeaway I
yeah.
get from this whole thing, it's a
Yeah.
tool,
Yeah.
which is great.
All
it
right.
does relieve some pressure, when you do have these extreme cases.
Yeah, you see, just to answer that particular, I think the question was, you know, you under a lot of pressure as it is. For me, when I look from the outside in, I just see roles and responsibilities that boards and health departments have sort of, through osmosis, just accepted. And there's no policy that's giving you direction in what to do. Classic example is traditionally health departments give the property owners, you know, a great deal of leniency. They give them, you know, time to go and fix, and they consider the inability, not necessarily the unwillingness, but inability of the property owner to bring the property into compliance. And then it's exacerbated by if there are tenants. And then the property owner says, well, I'm not fixing the bathroom because they're not paying rent. That's not an excuse. That is the court's, you don't have authority, and me as an individual don't have authority to enforce that. But the courts do. It's the responsibility of the property owner to bring the property into compliance.
Thank you, Alan. I do want to move on to other topics that we have to get to tonight, but I do at least want to thank you for your time, first of all, and give one more opportunity to the board in case anybody has any different specific questions they would like to ask Alan before we move on.
None?
None? All right, Alan, thank you for explaining this other tool that we have at our disposal. Like I said, my first exposure to it. And like I think it's a tool in the toolbox to be used in the future. Yeah, thank you for your time.
Thank you, Mr. Chairman, and thank you for your time.
All right.
We have to switch him out of presenter mode.
Yeah.
So we can just keep on with the work session, and I'll end with director's update if you want to do that way, and we can have the discussion for the,
Probably makes sense. All right. Work session, the accessory dwelling unit and septic tank internal guidance. So we have here the ADU septic system guidance from the health department. Carrie, is there any highlights or things that you want to point out, or anything that you feel need to be?
no, so this would be the set of circumstances that we would adhere to moving forward if the board feels it's appropriate for being able to allow ADUs to be constructed without requiring the multi-compartment tank. So this is just kind of a guidance, that way the ones like Briar Brooks from tonight don't have to come in front of the board. If there's a set of circumstances that we could just do a blanket approval for.
Fair enough, yeah.
This was drafted based off of that technical bulletin and guidance that we received. So this would just be a blanket approval that we
Blanket
could,
approval things that wouldn't have to come to the board would just get approved by the health department at the health department
at the
level.
local level, and we could set, conditions for those approvals. Like if the system needs to be upgraded, then the tank should be upgraded too. Certain flow capacities, it's gonna be limited, it's not gonna be like you're allowing a 6-bedroom, they'll need a bigger tank, so.
All right. Any questions from the board on this? So we can move to accept this guidance and allow for these units with approval from the health department before coming to the board at this point?
So we have to vote, right?
Yep. So you would vote to approve this guidance for us to follow at a departmental staff level.
I motion to approve the, I just went blank, sorry.
Yep, the
Accessory
guidance.
dwelling unit, title 5 subject to these
Uh,
guidance.
That, no, I'm going to, somebody else do it, please.
I move to approve the guidance for accessory dwelling units, the Title V septic system, giving the health department guidelines to approve ADUs without them being brought to the Board of Health.
Yep.
Second.
A vote.
Aye.
Beautiful.
Aye. All right.
No, I just stumbled on it.
We got a
It's
little
all
bit.
been there.
Yeah. Yeah.
All right. The automatic response to town emails.
So this is what we drafted, that all board members can set as their automatic response. So, and we can help set that up for you if you don't
did
know
it.
how to create an automatic response. It just kind of instructing people who may contact you for different things, you know, that it's not monitored on a regular basis. If they need immediate assistance, to contact the health department. If they're looking for records requests, they can go to the town clerk. And then just a kind of a notice about open meeting violation laws and things that you will and will not discuss through these emails.
So now is this anything that we need to vote on? Is this just like we can put this up on our own?
So if you
Or
like
is-
the language, if you don't want to change anything in it, if there's anything that you want to add, we can add. If you're happy with it, then you can take this and use it.
So
And we
how do
can send
do
you
it?
we can send you an email version of this, so you can copy and paste it. If you need help setting up your automatic response, you can come in and we can help you through that too.
Donna probably do that.
I'm on vacation. That's my automatic response.
So do we need to vote on this as a board to accept this as a response?
No, I just think that if there was any input, if you wanted to change anything, you don't have to use it, but I would say that if you are gonna use an automatic response, it's best to have it be uniform.
Something
Yeah.
uniform, absolutely. Does anybody have anything they'd like to see added to this response as it's presented? Yeah, I think great for now. I think it's one of those things that only time will tell if there's anything else that we need to add to it.
Right.
So, I mean, if this could be sent out separately and easily
Copy and
copy
paste
and
vote.
paste, I mean, let's just make it as easy. It's already written up
Absolutely.
somewhere. If we could make that as easy as
Absolutely.
possible, that would be fantastic.
Yep. We'll
All right.
we'll send that out, this week.
Thank you.
Yep. And if anybody needs help, we are a little tech savvy around here.
All right.
Stephanie is
I met with-
our guru, so.
Who did I meet with the other day?
Sarah,
She was wonderful for me. She really helped me a lot.
Yep.
So, modification to Board of Health meeting in May.
Yep, so our original meeting date was set for our annual town meeting. As always, we are asked to change that. So the meeting, the Griffin Room is already booked for the Monday and Wednesday of our normal week. So if we wanted to meet in the Griffin Room, we'd be looking to meet a week early that month on a Wednesday, the 13th. If we want to meet in this room, we have a little bit more availability to do the 12th, the 13th, or the 27th. So question is, do we want to meet early that month or later that month?
Early.
Yeah, I don't know the graduation date of my granddaughter, so
Okay.
I don't wanna take a chance
Okay.
of the
Guess it comes down to,
27th.
in general, then if we all agree, probably earlier is better. It does Tuesday or Wednesday. I don't think meeting in here versus the Griffin Room comes into play for me.
Same.
I don't care where we meet. Does Tuesday or Wednesday work best
Yeah,
for people?
Doesn't matter.
Fine.
I think earlier in
Earlier
May is
better.
better because then the weather gets so nice.
So my only concern about this room is if we have a meeting any bigger than we had tonight, this room would be hard to accommodate. We may have nothing on the agenda, but we don't know, so.
Well, we could do the 13th
I would say
in the
if
Don B.
Wednesday
Griffin room.
is.
Still early enough if we're talking the 12th or
Yeah.
13th. Nobody has a problem with the Wednesday.
Mm-mm.
Not at all.
I'd say let's keep it to the Don B. Griffin room on Wednesday the 13th then.
Sounds good.
Sounds good. That's easy.
All right. I move the May meeting for the Board of Health to Wednesday, May 13th at 6:30 in the Don B. Griffin room.
Second.
Vote?
Aye.
Aye.
Okay.
Gary, you're up.
So, we have an epidemiology update from January 9th. Our county contracted epidemiologist Leah Hamner has put together some great statistics for us. Flu activity is very high, at very high levels, with many hospitalizations, which I don't think I'm telling anything to this room that you don't already know in your field of work. It is high time to take measures to protect yourself from respiratory viruses. The entire state of Massachusetts is seeing very high levels of influenza. Like illness activity, we usually can see an increase in transmission following the holidays, but this year's flu season is hitting earlier and harder. Last year, 24 to 25, was the worst year for seasonal flu in a decade. This year, we're on track to break that record again. The dominant strain nationally is influenza A, H3N2, subclade K. The strain emerged 4 months after this year's flu vaccine was developed. While the available vaccine is not a perfect match to prevent getting sick altogether, it is still have been shown to provide protection against severe illness, including hospitalization and death. COVID-19 activity is also increasing, though few are getting critically ill. Multiple data sources for COVID-19 activity, including wastewater data and case counts, showing increasing viral activity. Indicators of severity, emergency department visits, and hospitalizations are low, meaning that this winter wave is not looking particularly dangerous so far. RSV levels are low. Take action today to spare yourself of wintertime misery. Vaccine, masking, social distancing, hand washing, stay home when sick, and clean your air all adds layers of protection against these viruses. Choose what works for you, but know that more levels of protection that you add, the less likely you are to become sick or get others sick.
I thought it said to take action and spray yourself. I'm like, what? Spray yourself.
No, no, no.
Being epidemiology is the class I'm taking right now for my bachelor's.
Oh, good for you.
Yes.
Yeah,
Lots of interesting stuff then.
yeah.
So far, mostly math, so right in my wheelhouse.
Good.
I was done with last week's project like 3 days early. Got to relax and enjoy the football over the
Well, good
weekend.
for you.
Very nice.
Good for you.
Oh, good for you.
Yeah.
All right. Move to adjourn.
Second.
Vote.
Aye.
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 All right.
All right.
Thanks, Karen.